Thank you all. Please have a seat. Good morning, everyone. All right. This morning we're hearing the case People versus Brooks. May I have the entry of appearances, please? Ms. Trout, welcome. For the defendant, please.
Your Honor, Sean Conley with Drew Nielsen for respondent in the first place.
And will you be doing the entirety of the argument, Mr.? Thank you. Welcome. All right. As you can see, this case has been set for 1 hour. That means each of you have half an hour. Ms. Trout, you will have to keep track of your own time if you wish to save something for rebuttal. Please go ahead whenever you're ready.
I'm going to attempt to reserve maybe 5 minutes in rebuttal.
Sure. Could you speak into the microphone just a little bit better? That should be good. That's perfect. Thank you.
Thank you. The people are here today requesting that the court issue a ruling that the statutory provisions 18-1.3-401, subsection 4, subsection C, subsection Roman numeral 1 and capital A, and subsections 2 and 3 are unconstitutional special legislation. And to avoid that type of mouthful in the future, I'm just going to call it the challenged provisions. We are supportive of the district court's first ruling in this case, which did hold these provisions to be unconstitutional special legislation. We're also asking that the court, in addition to making that finding as a corollary finding, we're asking the court to establish or to hold that life with possibility of parole at 40 is the appropriate sentence for Mr. Brooks and for the others in the class of 16 juvenile felony murderers. In the people's estimation, before we get to the analysis that was utilized in Canister, the prohibited enumeration, which we believe is present in this case, we'd like to just comment on the legislature's conduct as to whether it's reasonable or whether it's arbitrary and capricious. And this really goes to the last sentence of the constitutional provision, which basically says that you should not enact general, or you should not enact special laws where general laws can be made applicable. And in this situation, the first determination we understand as to whether a law should be general or whether there's no choice but to have a special law is the legislature's. And the first form of an abuse of discretion that we see when we look at this record is that the legislature, to our review of the record, did not even consider the situation, did not consider the issue, did not seem to see the issue of special versus general legislation. And I think one can infer that, even if one does not listen to all the legislative tapes, particularly the two, one before the Senate Judiciary Committee and one before the House Judiciary Committee, just the stated reasons that the legislature gives for enacting this special law indicate a failure to perceive, in our view, the underlying problem. The first reason that they incorporate into their statute is, well, we're doing this because of Miller-Montgomery. I mean, the inference kind of is, I think, to other legislators who may be considering, do we really want to give a certain small number of felony murderers who have fairly heinous and deadly crimes a more lenient sentence? Do we want to do that? Well, the inference that you can draw from some of these legislative tapes and the statements from some of the sponsors is that, well, we have to, it's a Miller-Montgomery thing.
Well, isn't that real, Ms. Trout? Over here.
Three of us are ready to ask the question at the same time. How is it not going to constitute special legislation, if it's in response to a Supreme Court edict? I mean, doesn't your argument prove too much? It's always going to be special in some sense, right? Because it's focused on responding to, in this instance, Miller-Montgomery.
Well, I don't think it's always special in every sense. And I don't think it's something that we've come to expect as a part of our judicial system. And under the facts of this case, I don't see what the legislature did as to the 34 other felony murderers as special legislation. Why? You can say, well, the class is closed, the Miller-Montgomery class is closed. And you can say, well, the Miller-Montgomery class, Ms. Trout, if you're saying the enumerated provision is practice in the courts, that applies equally to the 16, it applies equally to the 34. Yes, but here's the deal in my mind. Form should not be given precedence over substance. The remedy as to the 34 was just what everybody else has gotten, has been getting since 1985, is getting today, and I don't see how you can say there's anything special about the remedy for the 34 in the Miller-Montgomery class. And that's why we did not attack that portion of the statute as special legislation. In reality, it is simply making the same penalty available to all, with the additional benefit for all on earned time. Everybody's going to get earned time, and we think that's as it should be. And the earned time provision is new, but that is retroactive and it's prospective. But it's just this.
I guess I have, if I might interrupt, I guess I have trouble following that logic, because if, in fact, the provision you're relying on is the practice in the courts provision, all of the 2016 legislation falls into that. I mean, there's no other way for the General Assembly to respond to Miller-Montgomery other than to do something to address the sentencing hole that exists for this class of defendants.
Well, there are a number of other options, and I think that's the question. Is it a situation where the Supreme Court issues an edict that changes what our law has been? A response obviously must be made. But are there options between a general legislation response, as there are in this case, and a special response, a favoritism that rewards just basically 16 people who are, most of them or many of them, identified by name by the legislators? It was legislation specifically for them. They could have made this legislation prospective as well. They could have said, well, you know, we're going to respond to Miller v. Montgomery in a general legislative way, and our general legislative way as to the 34 is you get what everybody else has gotten. And I think that's general legislation. And then for you 16, we're also going to make this prospective so that juvenile felony murderers in the future, after the effective date of this bill, will also be getting this remedy. And then it won't be limited to just the favored few.
But aren't you just challenging the legislature's choice here? I mean, you're using buzzwords, and I get it, but why, you're assuming that this is special legislation for the 16. We've had briefing in this case. There may be a cold case where somebody else can fit in this. The Denver District Attorney's amicus brief points out an ineffective assistance context. Why cannot the legislature make a choice that says, in a felony murder situation where a juvenile was not the trigger person, as in this case, we think that person is less culpable? And why is that not general?
Well, I don't think you should be legislating specifically for Curtis Brooks or any other individual person unless there is a need for a special statute. What's the first step when you decide whether there should be a special statute as the legislature? The first step, I think, would be the legislature's got to recognize, which I question whether they did, the issue. Second, they need to address it. And maybe they don't need to make specific findings like, we have considered A, B, and C, and we now decide that we're going to have a special law rather than a general law. But there's got to be some initial determination. There wasn't even an initial determination.
Let me pose a different way to look at this. The legislature finds itself in a position where there is no sentence, a constitutional sentence for people between 1990 and 2006. So now we're looking at what do we do? And so we have to create legislation. So we create the legislation we did and create a rule for people who are committed felony murder different than others. Why is that irrational?
Well, Your Honor, I think, number one, they can create, for a sentencing void, they can create new sentencing legislation, but it is going to have to comply with the special legislation clause. So if it's an enumerated provision, or rather prohibition, which we submit it is based on canister, we find that case to be very similar to the one before the court today. If it is an enumerated prohibition, And if the class is closed, which I think it's clear this class is closed. I mean, one of the qualifying criteria is the sentence life without parole and having already received that, and that's only going to be this class of Miller Montgomery that includes approximately 50 people. So under your case law, I think there is a case for right there finding this as special legislation. Okay, so does this then create some sort of a quandary? Whenever these two questions come back against the legislature, does that mean they could not have a special law? And under your law, I think the answer is clearly,
Well,
that's not what it means.
Ms. Trout, let me just jump in right there. When have we ever said that a closed class as large as 16 is not real?
I don't think you've ever said that. In my mind, that brings up the issue about, is there a magic number? And you've never addressed the number 16. But I don't think the magic number approach is really what this court's decisions are about. And for example, if you think about Canister and Hagos, the number was 2. And there were 2 people who were being very burdened by a particular statutory provision, and it was held to be special legislation. And then on the other end of the spectrum, you have the American Water Development case. Again, the magic number is 2. And there, the legislation is upheld. And it's upheld because it is determined that the language is sufficiently general that it could be applicable to additional stream systems within the state. And so what really is the difference? I think the difference is future applicability. I think it's prospectivity. And I think it's the actual language of the statute. So I don't think the magic number is the way to approach the problem. I have another
Well,
thought.
let me just interject there. The magic number in the Constitution is 1, isn't it?
Well, that is the language. I think that's a metaphor. I think even in the Canister case, for example, in the majority opinion, that was addressed. Can you only have a special class if there's just 1 within it? And the answer to that was no. And obviously with Canister and Hagos, we have 2. So that would be my thinking. You don't need just the number 1. That's not a magic number either.
While we're on the topic, go ahead, Justin.
No, go ahead.
Well, just to follow up on this, can you respond to opposing counsel's assertion that it's not really a closed class of 16? In other words, there's still possibility, cold cases, post-conviction review, ways in which the class could expand. Can you respond to that?
Which was my question.
Was
Thank
that
you.
it? Okay.
Right, so.
Right. I don't think the class can expand. If you've got a cold case, say, and it's committed within, the offense is committed within the requisite time period, and the person is somehow later discovered, and say he goes to trial tomorrow, he will never be getting life without possibility of parole. He will never get that sentence. He will never fit within the parameters of the 30 to 50-year determinate sentence because
But what sentence would apply to such a candidate?
I think that the trial court was correct when the trial court said there may be a little sentencing gap here. And I agree with the trial court that as to that particular individual, if he should ever, or she, materialize, that they wouldn't be within the provision we're discussing today, and then there would be another question as to what do we do again in a situation where there is no specified penalty or the specified penalty was set aside as unconstitutional. But nonetheless, it doesn't expand this class. The same thing with the example that was cited by the defense in the district court, and that was the post-conviction relief example where, well, the person tomorrow or whenever files, they receive life without parole, they file a successful post-conviction relief motion, their life without parole is going to be set aside, but they're never going to get life without parole again. They're going to, does that make sense? They're going to stay within that category. We've only got 50 in the category. So I think that's right. Oh, I realize, here's the difference. The difference is, in the trial court, the defense was talking about, they get the motion for post-conviction relief, they have some success, they get a new trial, they get tried again. Well, they get tried again, they're going to get a new conviction that's not going to be with a sentence of life without parole. So they're not really expanding the class. Then there was a little tiny wrinkle in that same issue that came up, I thought, in Denver's brief. And Denver's brief, the little wrinkle was, we're still going to talk about post-conviction relief. And suppose somebody goes and is successful, but instead of being granted a new trial, where they go to trial and they basically get a new conviction, the judge just amends the minimus. And so we amend the minimus, and maybe we have relation back theory on this, and it so relates back, and therefore, one of the people in the class of 34, somebody who may have had a murder after deliberation conviction, they're going to scoot from the class of 34 over to the class of 16. And therefore, the class is not closed. Wrong. I think that's wrong. The class is closed. Now, the person described in Denver's brief is what I would call an unidentified member of the challenged provision class. I can't see him today because I can't read the future. I did my best to try to, just based on court records, decide who do we know of today, and it's the 16. Could the class have someone added to it per Denver's example? Speculative, but not inconceivable. And does that make a
so the
difference?
class is then bigger than 16.
Pardon me?
Then the class becomes, there's somebody in addition to 16. So it's I'm sorry, but I'm having trouble understanding your argument. You said it's conceivable. Well, that means it's not closed.
But even if it happens, no, it doesn't, that I don't go there. Even if it happens, per the Denver example, and so far this is the only example that I thought created a wrinkle, and I had to think about it. But the thing is, maybe it's not really 16, maybe it's 15. Maybe the court records I relied on are inaccurate, so it's not really 16, it's 15. Or maybe the Denver example comes to pass, and so the class then will have 17. That doesn't mean it's not closed. It means it was an unidentified member of this challenged provision class to begin with.
So what's the definition? What's the difference between an unidentified member and not a closed class? I mean, isn't that the definition? It's not closed if there are unidentified members who could join it.
I don't think so. I think that what I'm talking about, it's an unidentified member. You have to look at the criteria that is set by the legislature. And that individual who would fit the Denver example, it's not something prospective. It's not something happening in the future like the United Airlines case, where the legislation is targeted at United Airlines, but it's not special legislation, even though there's just one United Airlines. There are other businesses in the future that could locate in Colorado, in the future that could qualify for incentives. That's why it's prospective.
Ms. Strout, may I interrupt you for a moment, please? It feels to me like you are really straining very hard, semantically and otherwise, to reach your position. And in light of that, I'm wondering about the legislature, which isn't as well trained, certainly, as you, and doesn't look at things quite as nuanced, perhaps, as you do. And I'm interested about your very first comment that the legislature didn't consider this with all due deliberation, and they simply reacted to Miller. So I'll now finally get to my question. What is it that you would have had them do in light of Miller and in light of this situation and the sentencing gap, which you identified, that they haven't done and that they haven't made, if you will, a record for doing?
They can't make a record for what, Your Honor?
And that they have made a record for doing. What was the legislature supposed to do? Go ahead, please. Were you not able to hear me?
I'm having a little bit of trouble, but I am getting it, I think.
Here's the bottom line. What was the legislature supposed to do? They aren't as smart as you. Don't quote me.
Don't quote me. I mean, that's...
So what were they supposed to do?
Well, I think there were numerous possible general statutes that would have answered this problem. 3 of them I noted in my brief. 1, they could have elected to simply leave the Tate solution in place. They don't have to. It's their prerogative to change it, but that's something they could have done. I don't see that that was ever considered. They could have given all members of this closed class the same penalty, life without possibility of parole, with the earned time, which is an added benefit that all others are receiving. They could have done that. They could have given this limited 16 people the special benefit of the 30 to 50 provision, but also made it generally applicable to these up-and-coming people who are up-and-coming after the final date.
So your argument is that any of those things would have been constitutional, but they chose the one unconstitutional solution to this problem.
Well, I'll just quote the district court in its first decision, or I'll paraphrase. I don't think I can quote word for word. But he basically said the legislature had numerous options, and at the end of his first order, he listed two, had numerous options, but they selected the one thing they're not permitted to do under the special legislation clause, which is reward just 16 favored people. Now, that's a
Of course, the
paraphrase.
district judge changed his mind.
He did.
Yes, and so
Yes, he
let's
did.
talk about the second opinion. I mean, you can't, what quote would you give me from the second opinion that would support your position?
Oh, the second opinion, I think, was entirely contrary to the first. And nothing in my mind really jumps out from the second opinion as supporting the first ruling in any way at all. It was a complete, I think, reversal with one exception. I infer possibly the district court judge did not change his mind about the fact that this class is closed.
Of course,
I mean,
he
in his
circumvented.
first order,
He circumvented the problem altogether. If I may jump in, Chief?
Please.
yes.
Right, so he talked to us about practice and procedure versus substance, because we've been focused on this size of the class piece, which goes away if it's not an enumerated prohibition in the first instance, which of course is the linchpin of the second decision. So respond to that then, please.
Well, I think one of the arguments made by the defense in the lower court and adopted in the judge's second order was that there is a dichotomy between procedure versus substance. I don't see that dichotomy in this court's cases on the special legislation clause. I don't see it. I see in Canister, where we have two people, that there's a whole procedure. We're going to go back from 3-judge panel in the Capitol Arena to jury sentencing. We're going to have a procedure for doing this, and we're going to list factors to be considered during the course of this proceeding. But for you, Mr. Canister, and you, Mr. Hagos, we have a special provision because we just want to be sure that you are subject to the death penalty. And, you know, to me, that's an example of procedure having a very great substantive impact. They're also saying to Mr. Canister, meaning the legislature, and to Mr. Hagos, when you do go back for this new procedure, you're also going to be treated completely unlike any other defendant that's ever had a jury sentencing in a capital case. You're not going to get the same jury that actually heard the underlying guilt phase. I think that's an example of procedure having a substantive ramification. I think in this case, we've definitely got a procedure outlined for the court. It's very similar in a lot of ways to what was outlined in another area in Canister. We've still got factors to consider. A hearing will be held. The defendant must request it. I think that's very procedural, but it has substantive, huge substantive, I think, ramifications. Just the nature of the penalty you actually get is very, or potentially get, is very substantive, I think.
So, Ms. Trout, what is your definition of regulating the practice? I understand the argument you just made, but I'm not clear what you think regulating the practice means.
I think for me, not being on a bench anywhere, my job is to try to understand what you have said, and that becomes my position as a prosecutor. That's my job. And sometimes I have difficulty with that. But to answer the question, Canister is what guides my thinking. And Canister to me seems so similar in a lot of ways. And after the court in Canister got done discussing the whole statutory procedure that it was at issue in Canister and how it affected Canister and Hagos in a unique and punitive way, the court went on and said that the statutory provision, it had found enumerated prohibitions First, it regulates the practice in the courts of justice by directing that two specific capital cases be handled in a specific manner. Well, that is exactly what the legislation here does, as to 16 cases at this moment that must be handled in a very specific manner by the district court. And so to me, that would be my answer based on the case law I've read.
So wouldn't that, and it comes back, I guess, to what Justice Hood asked you, I mean, whenever there's a situation like this where a sentence is declared unconstitutional and we need to start over, we're always going to have a procedural element to it because there's now no sentence. We're going to have resentencing at a minimum. So why wouldn't it be the case that in every situation where we have, legislature steps in to fix a sentencing gap, we have regulating the practice because there's a procedural element?
Well, it's not just, if there's a procedural element and it applies to all the courts, then yes, one needs to look at the analysis. And I'm not certain, how the analysis will turn out on prong one enumerated prohibition. But if the answer is yes, then you look at the closed class. And if the
But is that
class-
regulating, I'm sorry to interrupt you, but is that regulating practice if there's a procedural element?
Well, I think there has to be a procedural element, yes.
So
And beyond
that would be regulating practice if there's a procedural element? Is that,
That's not my definition.
okay, but that's what I'm asking you.
Well, my
That's what it sounded like you were saying, in which case we always have that. That's my concern.
Well, we don't always, that's just one factor in the analysis. But it seems to me our enumerated prohibition could certainly include, as Canister did. I don't think that statute in Canister was strictly procedural. It had serious substantive impact on those two people, if not corrected. And then I think as well, even if there were some procedure with substantive elements to it that regulated the courts, you can have regulation of the courts as long as there's not a closed class. You can have regulation notwithstanding an enumerated prohibition as long as there's not a closed class.
But isn't there always going to be a closed class when the legislature is responding in the Miller-Montgomery situation to a 26-year period during which a certain number, an identifiable number, a closed number of people were sentenced under a regime that is now declared unconstitutional? It will always be a closed class.
And that's only one element of the analysis. And in addition to that, where you've got a situation with a closed class, specifically because the Supreme Court has changed its mind, then I think the question becomes, can we resolve this with a general law? In this case, the answer is yes. In some cases, the answer would be no. But I think you can look at two cases that this court has handled, again, one on each end of the spectrum. And I'll start with the Morgan County School District case. And that's a case where, it's the only case I know of from this court, where the legislation was upheld despite the fact it was special legislation. It was special legislation, it was a special law just for the college, or the college district they wanted to start. And the analysis, and that was fine. And the reason it was fine was because they went through the analysis, well, would a general law work here? And in fact, there was a general law in existence, and it talked about getting approval for establishing a school district. And all the criteria had been met, but the school board would not give its permission. And therefore, the legislature was stymied, so it enacted a special law, in essence, going around the school board, just to achieve the objective of establishing that college. And that was deemed to be very appropriate under the special legislation clause because the general law that was already there wasn't even working. So there is, within the constitutional provision, in my mind, certainly provision for a situation where the class is closed and there is no general legislation option. You can still solve the problem as the legislature.
How are the provisions in the 2016 law that apply to the other, not the 16, but the others, not also special legislation under your argument?
The only reason that I think it's not necessary to go through that analysis. And I can look at it and say, yeah, the 34, if it's an enumerated prohibition for the 16, it's an enumerated prohibition for the 34. If the class is closed for the 16, I think the class is closed under Miller-Montgomery, period. It's closed for the 34.
34 as well, right.
Right, right. So what's the big difference? In my mind, the big difference is getting back to, what do we do if we have an enumerated prohibition and we have a closed class? Answer, we enact general legislation if we can.
But the legislation that was enacted here does not apply to anyone other than those other 34.
True. And so to me, you could say, oops, that's the end of the analysis under the special legislation clause. I just can't go there, and the reason I can't go there is the truth of the matter is there's nothing special about it at all. What those 34 are getting is just what the juvenile offenders.
And that let me grab you right there, because I think really what your argument is you're concerned that the 16, by having access to the determinate provision, 30 to 50, are getting something of benefit that's unique to that class of 16. And I think what it troubles me a little bit about that argument is that's really more of the special privilege provision within the special legislation.
Well, we think both are applicable.
Well, and I guess my concern is, though, I didn't see that you had actually argued that below.
Well, we didn't argue it below, and then in the first decision, the judge utilized it as one of its grounds.
Not in the final trial order, though.
In the final order, he did not. In the final order, his final order was something more akin to, and I'm reading between the lines, I wish I hadn't really brought up that special privilege argument because it's probably really better than anything that people ever thought of to begin with, and I really don't want to include that in my second order. And he didn't. I think his second order was much more, I'm just going to answer what the people raised. And I thought about that, and I thought, well, I think the issue's been raised. I think it should be addressed and answered in this court. And I think it should be addressed and answered, even though in our original motion for constitutionality and the reply, we were talking about practice in the courts. And why do I think that? I think many, many, many times in lots of different situations, parties are very bound by exactly what they've said in the lower courts, as it should be. This is a matter, however, of, I think, especially great importance. It's people's liberty. It's something that affects every jurisdiction or almost every jurisdiction or half of our jurisdictions. I haven't really counted them up.
And I should probably cut you off there. You were.
Well, I just wanted to know if she's answered your question.
Yes, she has.
Yes,
Thank
you
you.
have answered the question. Thank you very much. We appreciate it. Mr. Connolly? That's okay. She was trying to answer.
Chief Justice Rice, and may it please the court, Sean Conley with Drew Nielsen for the respondent. Our client, Curtis Brooks, is special. This 2016 legislation curing systematic constitutional violations that plagued our juvenile sentencing system for 16 years is general, not special. There are three independent reasons why we contend that this legislation does not violate the special legislation clause. But before getting to them, if I could just take a step back and talk about the extraordinary posture of this case. The Arapahoe District Attorney, rather than faithfully executing the law, is attacking the law. And the law under attack is a law that the legislature had to pass to cure a gap that this court very reluctantly had to fill in Tate. The Arapahoe DA is asking this court to strike down that law, create a new gap, and then have this court fill the gap with a sentence harsher than the legislature prescribed and harsher than a sentencing judge in his or her discretion could find appropriate. In the name of a dusty old special legislation clause, the district attorney is actually turning separation of powers on their head. Now, if I could give three reasons why this is not unconstitutional special legislation. First, this is a real and genuine class of people that the legislature had to address, even assuming that the class is closed. Second, the class is not closed, if that made a difference. And third and finally, the case does not fall within the enumerated prohibition of a law regulating the practice in the courts. Let me start with number one. The question of special versus general legislation is the law addressing a real and genuine class rather than an illusory class? Justice Hood, I think, mentioned the metaphor has been, is this a class of one or is it a real class? And a class of one may not always literally be a class of one. We know in Canister there was a class of two. But the question, the threshold question, is this a real class where there's really a need and an obligation to legislate, or is this something where the legislation was unnecessary and was just singling out one or two or limited people of things? Never has there been the test in this court that a class is necessarily illusory rather than genuine if it's closed. Closed or open has only been used to save an illusory class of one. Classic example, United Airlines. 1991 legislation, the legislature said, we're going to give $115 billion handout, incentives, whatever, for building a maintenance facility in this town. Everybody knew, and the court took notice of this in 1991, everybody knew it was targeted at United Airlines. Everybody knew that the chance of it applying to anybody but United in the future was certainly speculative. The dissent certainly thought so. But the court nevertheless upheld the law, class of one law, and said even though it's intended to benefit United Airlines, even though it probably will only ever benefit United Airlines, there's at least a potential of it applying more broadly than that. The test, therefore, is, and this is the language in the interrogatory case, is this a real or a potential class? Never has it been said that you can't legislate retrospectively to address a real problem.
Well, we beat up on Ms. Trout pretty fast. I feel like we're not being a sufficiently hot bench as to you, Mr. Conley. So even if we agree with what you've just said, and that takes care of, say, the 50, respond to her argument that it's different when we move from the 50 to the 16, and there arguably the legislature is going beyond what was necessary to address the Miller-Montgomery problem.
Well, I think in terms of going beyond what necessary and arbitrary and capricious, this court doesn't sit as a board of review and say, is this legislature the best legislation or is it rational? Justice Cardozo, in an opinion that we quote at length and is quoted by this court in both the interrogatory case and Morgan, says that's a legislative judgment in terms of how to fine-tune a remedy. But if you have to act, if it's a real class of 50, as I don't know if they can see it or not, but if there's a real class of 50, then within that class, how do we treat that class? And is there a rational basis for saying that felony murders are different than premeditated or extreme indifference murders? They're all in kind of murder one, but there's a rationale that we're going to say that, and this is not overly lenient, the sentence is if the judge finds, in a felony murder case, as your honors know, finds extraordinary mitigating circumstances, then the judge may, but is not required to, do a determinate sentence of between 30 to 50 years, harsh sentence, or may still give the life 40 sentence. So this is just giving sentencing discretion. So within that class of 50, a real class, a class that the legislature under Miller-Montgomery had to address and provide curative legislation, or else it defaulted to this court. And this court wasn't happy with it. I read both the concurrence of the current Chief Justice and the dissent of the future Chief Justice, and as well as the majority opinion by Justice Ide. Nobody was happy with having to fill a gap. This court was acting in a quasi-legislative fashion that certainly troubled, I would suspect, the whole court. But the legislature here filled the gap, and they did it in a way that they had to act. They had to act to fill this gap. And then in terms of filling the gap, they rationally said, we think that felony murder sentences potentially are mitigating and potentially are less serious and deserve a little more leniency. It's not really leniency, than premeditated murder.
So does your argument become sort of like a Venn diagram? Anytime, you have a general class, then anything within it is necessarily general as well?
Well, I think within it...
You seem to be just going straight to sort of a rational basis argument with respect to the 16 once you've identified the 50 as being general.
I think once you say it's general legislation, you are on a rational basis. But I think once you say it's special legislation, not with an enumerated prohibition, you're within rational basis. But I think my argument is simply this, that there is a real class here. It's a real class of 50. And then there's a real subset class within that real class. And it's a real class of persons. And it's not 16, by the way. Their own addendum M counts 17 people that are within that class. And that class is growing and can potentially grow. It's not a closed class. That's my second point. But in terms of the first point, this is a real class of 50, and it's a real subclass of 16. Both of those are far divorced from a class of 1, where we unnecessarily and choosing to single out United Airlines, or in the 1961 case, choosing to single out Denver and Glendale and saying that one time only, Denver can annex Glendale. So one shot only, and that's going to expire next year. So it's not a real class, it's a class of 1. And if it's a class of 1, then the question becomes, can it ever grow? Is it something potentially more than 1? Now, I don't think you go through the analysis when you say in the first place, there's a real class here. Real class of 50, real class of 16 or 17, or I'd say 20 in the subset class, but these are 2 real classes. And they are drawn by a legislative classification, like all legislation classifies. The legislature has created a real class. Actually, in this case, they didn't really create the first class. The first class was created by Miller Montgomery, and the laws that they passed for a 16-year period, and the Supreme Court of the United States effectively created that class and needed addressing. The class they did create, by choice, is within that broader class. They created a class, and I don't think it's 16, I think it's 17, I think it's 20. We can debate how big that subset class is, but they created that class, and that's a reasonable class. And I don't think you use a special legislation clause to say that they're disempowered from doing that. That's a purely legislative judgment.
Whatever the size of that subclass, 16, 15, 20, it is bound, at least in terms of the date of the commission of the offense, right?
It is the same 16-year period.
In that 16-year period, so the commission of the offense would have to have occurred within that 16-year period.
Correct.
What about your opponent's argument that by treating whoever, whether it's 16 or 15 within that band, allowing them to have access to a 30 to 50-year determinate sentence is conferring on them a special privilege that is not afforded to juveniles who committed felony murder prior to 95 or post-2006?
Well, first of all, I think it's a general class, so I don't think you get into the special privilege, and I can talk about that enumeration, which was not argued below, and Judge Samore specifically pointed that out in footnote 9 on page 10 that is effectively waived.
So you're considering the argument forfeited, but assuming for the sake...
I think maybe waived instead of forfeited,
okay.
but certainly at least forfeited.
Assuming that it's still on the table, why is it... Could you address it on the merits?
Well, that gets into my third point, why this is not within an enumerated prohibition. I think you don't even get to that third point unless you say this is a special law. And my broader point is this is a general law. And it's a general law if you view it as a closed class of 50 or as a closed class of 16, because these are broad general standards that are not singling out a class of 1, that are dealing with a problem that was thrust upon the legislature by their own sentencing choices for that 16-year period, and then by the later Supreme Court decisions of saying your choices are fundamentally unconstitutional, and they have to fix it. So I think if you say that this is a general law, you don't even get to all those analyses of what enumerated prohibition. I think my second point is, and I'm happy to jump ahead to your point in terms of why I think the special privilege. I don't think get there for point 1 because it's a general, not special law. Point 2 because it's not a closed class. And then point 3 you only get to if you say, okay, they've jumped through all those hoops. This is special law. But is it a special law affecting enumerated prohibition? The judge said it doesn't affect practice and procedure. We can talk about that. And then the judge said he had originally raised it might be a special privilege, but then he said that was forfeited or waived in his footnote, and I'm not going to address that further. If you want to address, so I think, number 1, you don't address it. Number 2, I would say that clause says you cannot have special laws creating a special privilege, immunity, or franchise. That's read as whole. I think this is not a privilege in any sense. The dictionary definition of a privilege, attorney-client privilege, it's an exemption from a duty imposed on you. And I think it goes in terms of pari materia with privilege, immunity, or franchise. These are affirmative acts being bestowed on somebody. If you said it applies whenever one person is treated more beneficially than another, then you're basically rewriting enumerated prohibition to say any special law falls within an enumerated prohibition, because anytime you treat somebody better than another, you're privileging them. I think that's giving way too far in a definition of privilege, to say that if you're treated better than somebody else, you are, quote, privileged. You're basically saying that every law, special law, falls within the enumerated prohibition of that.
Let me come at it from a slightly different angle. And just thinking about the consequences of whatever this court decides in this case, assuming that the court were to uphold this law, would a juvenile defendant who is outside this class, either pre-95 or post-2006, who does not have access to that determinate sentencing range, have an equal protection claim because they're being treated differently?
And I think Judge Samour's opinion didn't go on this first ground, but I think talked about, very importantly, the differences between somebody in this class, the class that nobody wants to be in, this class of 1990. My client didn't want to be in this class. 1990 to 2006 had the harshest sentencing ever imposed in juveniles. Juvenile mandatory life without parole. Now, the effect of that is I think that those people, and Judge Samour's opinion did a very nice job of this, that those people are treated differently than people today would be. And that said, well, I may not get that possible determinate 30 to 50-year sentence. But let's look at the other things. My client, Curtis Brooks, 15 years old when this happened. If this happened today, he couldn't be direct filed on in Arapahoe County Adult Court. He'd have to be filed on in juvenile court. There'd have to be a transfer hearing where you'd look at a lot of the factors that you're looking at in terms of extraordinary mitigation. What's his age? What's his maturity level? What's his role in the offense? Should he even be transferred in the first place from a juvenile court to an adult court? He didn't have that option. So the laws was different then. And then if he is ultimately transferred, he'd have the chance to argue mitigation and say, keep me in juvenile court. If he is ultimately transferred, he'd be facing now a maximum penalty of life 40. He never had a chance to plea bargain. Other people, other defendants had a chance to plea bargain. One of the defendants, the leader, was charged in juvenile court because he was younger. Another person had a chance to plea bargain and got a second-degree determinate sentence. If he were charged today, first he could have a good argument to stay in juvenile court as a 15-year-old. If he lost that argument and the prosecutor convinced the court to move him up to adult court, he'd have a maximum sentence of life 40, from which any plea bargaining could be going down from there. So they're really not, the long answer to your question is...
I guess I'm just wondering if 2 years from now we're going to be hit with a raft of equal protection arguments by that.
Perhaps, but I think there's an argument that they are not similarly situated, that what he's gone through, the way he was charged in 1995 and the way anybody like him was charged in 1995, and the fact that he had to live for 2 decades under an unconstitutional life without parole sentence, when a lot of people would give up hope, but he didn't, and that's a different story that we'd like to present someday, and we started to present that to the trial judge in terms of the extraordinary mitigation in this case. But all those factors differentiate, and the trial judge talked about them, differentiate somebody in that unfortunate 16-year category when Colorado was unconstitutionally sentencing juveniles mandatorily from somebody that would be charged today. So I think, I can't say you're never going to face that, but I think there's certainly ways to say that they are differently situated. And I think Judge Samour started down that path about why this class is not being specially privileged. In fact, suffered more than somebody would today even. And somebody today would not ever be in the situation when they were in.
Thank you.
Mr. Conley, can I back you up for a minute? So I understand your analysis, which you start by, if it's general legislation, we're not even in the special legislation clause. We don't have to go down any of this road. We obviously have to write an opinion here. I'm not sure I heard a clear definition of what you would define general legislation as versus special legislation. So help me with that.
Well, the test, and you know, the test is it a real or genuine classification, or is it an illusory class of one? That's the kind of fundamental distinction. And you've not
so we seem to then, and that's where I'm getting confused, because if we do, and I have to say in the amicus brief from the Denver DA, I love the chart. Their little analytical chart was very helpful to me. As they put it, and this is how I understood the law. First, you decide if it's an enumerated category. If yes, you decide if the class is illusory. If no, you decide if its class is reasonable. You are defining general as, is the class illusory, which seems to me you decide after you decide if it's enumerated. So I'm a little bit confused.
All right, I love the Denver DA, the chart, and I love the author. I disagree with the author in one respect. I think the analysis textually, and there's support in Canister and interrogatory case for that methodology. I would suggest as a plain textual matter, the text of the Constitution says we prohibit special legislation, special or local legislation affecting these enumerated classes. I think textually there's a good argument to say, first of all, is this special legislation, and cut it off at the pass. And if it's general legislation, you can knock it out there without saying, is it enumerated prohibition? So I would flip that analysis, and that's analysis that this court has suggested in Canister, But I think textually, the first question could be, and I think you have discretion to say where are we going to decide it, at what level. So I don't think you have to follow that rigid question 1, 2, 3 methodology. I think you can say question 1, is it special or general? And only if it's special, then do we have to say, is it also within an enumerated prohibition?
So it's general if it's not an illusory class.
That's the demarcation this court has said. Is there a real or genuine class? And the cases it's had to deal with, it was clear it was not a real class unless there was some potential future applicability. Glendale annexation, clear they wanted to target that one annexation by Denver in 1961. United Airlines, clear they wanted to target United. And the only reason it was saved is because potentially it could apply more broadly. Even though it probably wouldn't, it potentially could. I think Canister, close, it was a class of 2. Close enough, they said class of 1 may not be literal, but it's a class of 2 that I think Canister also said the part of the goal of this special legislation prohibition is we want to stop unnecessary laws. This is not a necessary law in Canister. Canister, there was a default. Only 2 people were affected. The Supreme Court in Ring, in a procedural decision, said that we need jury sentencing in capital cases.
So wasn't that actually pretty analogous to the situation here? The court said that a procedure that we were using was unconstitutional. The legislature needed to respond to address that?
But, Your Honor, the legislature didn't need to respond for this reason. The default option there was life without parole. And so if the legislature did nothing, the courts are already fully equipped to deal with that. And two capital defendants would not have gotten death sentences that the people want to impose. And prospectively, everybody else would. But the default there was Canister and Hagos get life without parole. There's no default here. Absent this legislation, you've got 50 defendants out there that this court in Tate had to fill a gap. There was no gap to be filled in Canister. The gap this court, I say reluctantly, had to fill in Tate. And at Tate, by the way, over dissent by 2 of the justices on my right, the court said, no big problem here. It's only going to be prospective. Only people with direct appeals are going to be affected. And so it was a narrow problem than Tate even thought. Now, Montgomery comes out some months after Tate and says, hey, this is a bigger problem. You got a bigger problem on your hands than Tate even thought. And Tate didn't like filling the gap for 2 or 3 direct appeal people. So that's, I think, the key distinction in Canister. The legislature did not have to act there. And when Canister says part of the goal of special legislation is to prohibit unnecessary legislation.
Mr. Connolly, if I can ask you to walk through so your chart is different than the charts we were talking about. Help me through then the analysis. So first we ask if there's an illusory class. If there's not, it's general, we're good, end of story. All right, but if we say it's an illusory class, then we have to look at it's an enumerated category.
No, I'd say one other thing. So illusory, then step 2 is you look at it, is it closed?
Okay.
Because United Airlines
So walk
was
me
illusory.
through that.
All right, so that's my second step, I guess. I kind of frame in the flow chart a little differently. And I don't think there's any rigidity here. I think you could take it at any step you want. But step 2 in the analysis I'm proposing is, okay, we've got an illusory class. It's a class of 1, class of 2, class of 16 here. I think you're really pushing beyond the boundaries of this court's precedents. But we've got an illusory class. Can we save it then? And in Glendale annexation, they said you can't save it because the legislation is drawn so it can never apply to anybody else. United Airlines, they said it's unlikely it's ever going to apply to anybody else, but there's at least that potential. So there's maybe not a real class now, but there's a potential class. And that's where you get into the closed. I think the closed comes in step 2, not in step 1. I think you could have a real closed class, I guess is my step 1. I think you have, even if you have a closed, and I think they concede maybe that the class of 50 is a real closed class.
And you don't think that our earlier decisions have held that a closed class is an illusory class by definition?
I don't think you've ever said that, even close. I think you've said, and interrogatory says, is it a real or potential class? I think potential goes to, it may be not real now, but there's a potential because it's open. I don't think there's ever, and I think the commentary, we cited a law review article by Professor Schutz that talks about these are, this kind of Colorado legislation is one of 46 states, I think, have this back from the late 19th century, have this kind of provision. Very strong argument there. Closed class is not illusory. Sutherland on statutory construction, we talk about curative acts oftentimes only apply to the past. And if you say a closed class is necessarily illusory and not real, you're saying that a legislature is disabled from passing curative legislation. So no, I would very strong. That's my point 1. But my point 2, that closed class is not necessarily illusory. But if that is the key, this class is not closed. And I think this is where the Denver DA does an excellent job in terms of explaining There are two ways, at least, and I think everybody agrees, there are two ways that somebody could still be sentenced to felony murder for a crime committed as a juvenile in that infamous 16-year 1990 to 2006 period. One is a closed case, and we can talk about that. The second is somebody who's convicted of only, let's say, premeditated murder right now, would have received a mandatory unconstitutional sentence of life without parole for that period. So somebody in the class of 50 that then, in a Rule 35C, and this has already happened, we submitted a chart. There's a fellow named Jacob Eind that just had in Teller County, in this class of 50, that just had a successful 35C, and right now he has no conviction. But there's a potential that somebody could either be convicted of premeditated murder and then have that set aside by agreement or by 35C and be charged with felony murder. That person would expand the class beyond 16 or 17 or 20, and it would not be closed because it would apply to that person. And that person would have been, within the literal language of this C1 provision, would have received a sentence of life without parole. And that person also now would only be convicted solely of felony murder. So what do you do for that person? That person, under the statute as written, would be eligible for this determinate sentence if they showed extraordinary mitigating circumstances. So I think it's not closed in that respect. It also begs the question, I think Justice Marquez maybe asked this, what about somebody in a cold case that is caught today, not within this class of 50, where did they get sentenced to? And I think they've got to be covered by this provision because there's no other provision that applies. If you look at, there are really three provisions in Section 401. One is 1A14, I think it is, that says the sentence is life in prison for a Class 1 felony. The next one is Section 4A that says in this 16-year period, life means a life without possibility of parole. And then you've got this subsection C1 that says, notwithstanding those two provisions, there's an exception here. So those two provisions are still on the books. It says, notwithstanding these, a person convicted of felony murder during this period may still receive a determinate sentence of 30 to 50 years or life 40 in case of extraordinary mitigating circumstances. So if you strike this provision as unconstitutional, the only sentence on the books left for a cold case murder by a juvenile during that period is mandatory life without parole. So that person, I don't know what you do to that person. I guess you could say to that person, I'm giving you mandatory life without parole, and then all of a sudden, I know that's unconstitutional, so therefore you're now subject to this sentence because you have received a sentence of life without parole. There's simply no other sentence on the books. So this attack is creating multiple gaps in the law that, again, they're asking courts to fill. And this all at the behest of an old, obscure special legislation clause that I fundamentally think is turning much more important separation of powers principles on their head, asking the court to step in and overturn legislation that it then has to fill with its own gap. So I think that's my, I guess just to, again, and just Gabriel, I don't think the order particularly matters. I would propose textually say first is this special or general. And I think that's a cleaner way of analysis. And I think it is general because it's a necessary law that the General Assembly had to pass to fill a gap that was not of their own making.
I'm interrupting
Yes,
you,
ma'am.
I apologize. Assuming that we like the Denver DA's chart, or even if we didn't, I think your third point was going to be this doesn't fall into an enumerated
Yep.
provision.
Yep, thank you for getting me back on track. So in terms of the enumerated prohibition, which applies if it is special legislation, would be regulating practice in Colorado courts. The challenge provision of SB 181, which is now in the statute, is Section 1 of SB 181. That's the provision that allows a determinate sentence of 30 to 50 years if there are extraordinary mitigating circumstances. And then subsection 10, or Section 10 of SB 181, is much more procedural and says, here's how this resentencing hearing shall proceed. So the question, and they're not attacking that, I don't think. Section 1, though, is substance in our view, and the district court so held. And I think if you say, what is the definition of practice? I think practice is procedure. I mean, if you look at the leading federal treatise that this court cites a lot of times, right in Miller, Federal Practice and Procedure, the dictionary in Black's practice is procedure. The district court, I think it's hard to say that practice means anything other than procedure. And it's not just a dictionary, it's really the way this court in 1881 in the Stout and White cases, and then in the 1968 Sanders case, where they said, created actually special courts in Arapahoe and Lake counties in 1881, said the problem is not creating special courts in these counties, even though there are other counties with population above 15,000 at the time. The problem is then saying you can have special rules of practice here. The special legislation clause and a related clause in the Constitution are meant to have uniform statewide practice. That when I walk into Arapahoe County, I'm having the same rule book as I am in Denver County. And not to say, oh, we don't do it like that in Arapahoe. Maybe some judges will say, I don't do it in this courtroom down the hall. It might be different, but the whole point of the special legislation clause is to have uniformity in this state.
So does it have to be wholly procedural, partially procedural? I mean, you say procedure, I get that. Canister, I guess you would say what's the special procedure was we're going to impanel a new jury for these two guys.
That strikes me as
and
procedural.
yeah, and so, but there was also a substantive aspect to that. So help me with that. I mean, if there's any procedural aspect, wholly procedural, how do we decide that?
Yeah, I guess what predominates is one. I mean, a canister, to get to that, was involved two enumerated prohibitions, which may be why they didn't look at the procedural one quite as closely, but involved, impaneling pettit and grand juries was another part of the enumerated prohibition, clearly applied there, and said there's another one that applies also, special legislation affecting practice. I think much more clearly procedural says you impanel a jury. That's a method of procedural. It may have secondary substantive ramifications. We know, well, go to this way. Ring versus Arizona is the Supreme Court, U.S. Supreme Court that struck it down. The Supreme Court declined to apply Ring retroactively in Shiro because they said this is a procedural holding. Contrast that to this case. So I mean, the very rule that gave rise to canister was held procedural by the U.S. Supreme Court. Contrast that with this. The Supreme Court, as the court knows in Miller, says, you cannot give mandatory LWOP sentences to juveniles. 4 years later in Montgomery, the argument is that procedural or substantive? The Supreme Court said, no, it's substantive. It applies retroactively. So the line I'm trying to draw, I think, is a line drawn by the Supreme Court in Ring and Shiro versus the line they drew in Miller and Montgomery. So I think this aspect of saying that no longer, here's a sentence you're eligible for, a sentence is substantive. How do you impose that sentence? May have procedural ramifications, but it's predominantly substantive. Contrast that to, I think, the canister case where it's predominantly procedural. Certainly there may be some substantive secondary impact, but that's why I say that in terms of the third category of our analysis, or the first category of the DA's analysis in Denver, that is why I think that this, Judge Samore correctly held that this was not regulated practice. This was a substantive change in Section 1 that the legislature is entitled to make. So for all those reasons, we'd ask this court to uphold the law, which simply allows my client, Curtis Brooks, who, as I said, is special, to make that case of why he has extraordinary mitigating circumstances to a district judge who, in his discretion or her discretion now, can decide, if I agree that there's extraordinary mitigation, then I can impose a sentence of 30 years determinate. And we ask the court to discharge the rule and uphold the statute. Thank you.
All right, thank you, Mr. Connolly. Ms. Stroud, I'm sorry you don't have any remaining time. So the case is submitted. We are in recess until tomorrow.